the 17th of October 2024. I determined that the best way to understand parties' positions and further my understanding would be to hold a hearing session. We're here today to participate in that hearing, and I'd like to thank parties for understanding and postponing this hearing in my absence. Now, before I cover some administrative points, could I ask everyone to introduce themselves, and I'll start with the appellant. Thank you.
Good morning, sir. I'm Alistair Burnett, King's Counsel. I'm representing the appellant. I have with me in the same room Mr. Jerry Casina and Mr. Robert McConville from the appellant, Allied Vehicles, and also my instructing solicitors, Liam Riley and Robbie McAdam from Holmes McKillop. We also have online two people from Fairhurst, Mr. John Stevens, Mr. Brian Ward, who are in separate locations but available to speak to structural matters if you so desire, sir.
I think the biggest problem is going to come. There's a lot of exemptions for.
Thank you very much. Sorry, Mr. Ward, who is the second person from your company there?
It's John Stevens.
Thank you.
Well.
Thank you very much. And we move to Historic Environment Scotland.
Good morning, sir. My name is Cameron Gregg. I'm a solicitor at Morton Fraser McRoberts. I'm appearing on behalf of Historic Environment Scotland today. I'm joined by Mr. Darragh Parsons, who is the head of designations at Historic Environment Scotland, and by Ms. Dawn McDowell, the deputy head of designations. And I also have my colleague Rachel Cartwright in the room with us.
Thank you. And from Glasgow City Council.
Good morning, I'm Shona Simpson. I'm the Built Heritage Officer with Glasgow City Council. My role sits within the planning service. I'm here today with Alison Farrell.
Sorry, you're going to end up having to hear it on.
Good morning, my name is Alison Farrell. I'm the team manager of the Heritage Design and Landscape team that sits within the planning service of Glasgow City Council. And with us also we have Martin.
This one doesn't go as long.
I'm Martin Colvin. I'm the legal manager of the Glasgow City Council. I provide legal support and
Questions I asked. I've subsequently sent something to Linda yesterday about the
sometimes it's
the form for access.
Sometimes you'll be a dead short one.
Last year, October
Okay, thank you very much for your introductions. Now, some points of administration. Please note that today's meeting is being filmed for live and subsequent broadcast via the DPA's website. By participating, you are consenting to being filmed and to the use and storage of the images and sound recordings, and any information pertaining to you contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Any information presented to you, to myself, in addition to forming part of a recording that will be held as a historical record, will also be held and used by the DPA in connection with the relevant matter until that matter is decided or otherwise resolved, including any potential appeals and other consenting processes.
They're just terrible.
Thereafter, that information will continue to be held as part of the historical record. Now, are there any questions regarding the filming of this meeting today? And separately, by a show of hands, could you just show that you're all in agreement to being filmed today?
You have a pin for your card. You put the card.
Super, thank you. Now, we're not together today, so please be aware of the fire procedures in your own building. If the alarm does sound, please leave by the nearest exit and assemble wherever you would, and we will pause or postpone the hearing in the interim. You should all be aware of how to use the microphones, but if you switch them on when you're speaking and switch them off when you're not, that would be much appreciated. I'd also ask if you have a mobile phone, if you could keep that switched off or on silent during today's discussions. Now, I anticipate that this hearing will take around half a day, and we should finish around lunchtime. We'll start shortly and we'll have a break mid-morning and stop for lunch only if required. Now, while some of you might be well versed in hearing procedures, this may be others' first experience, and there will likely be some viewing procedures whom an explanation of hearings would be helpful. Hearings are a less formal process where I lead the discussion based on the agenda already circulated. In effect, we'll proceed through the agenda items and I will direct questions to those present, and that in turn can initiate discussion on a matter until I consider I have sufficient information. The purpose of the hearing is to enable me to enable the evidence relevant to the proposed development, or in this case, the building designation appeal, so that I can make an informed decision. Those participating should focus on that purpose. I'm not interested in point scoring or needless argument. I'll intervene if I think that responses do not assist me. While you might have differing opinions, my focus is that parties discuss matters in a fair and respectful manner. I don't see the need for formal closing submissions, but will give parties an opportunity to provide a summary of their case orally at the end of the hearing should they wish to do so. Now, are there any questions regarding these points of process and administration?
Pretty useless altogether, because really all they were talking about is
no. Does everybody have a copy of the hearing agenda?
Yes.
Brilliant. Now, did anyone who didn't take part in the building designation appeal hearing last month for 124 Craig Hall Road view the webcast?
Yeah, well.
Yes, sir, I have viewed it, and I believe that at least Mr. McConville has viewed at least part of it. I'm not sure that anyone else has viewed it from the appellant side. So
okay. Well, in that case, we may be able to take some of the matters more swiftly, relating back to that particular hearing. I'm conscious that this is a separate process, but also that many parties here will have a background arising from that particular hearing. Right, so we'll turn to the agenda items in turn. We've covered point 1, the purpose of the hearing and introductions. So I'm going to move on. Please be aware that I'll be typing at the same time, so I may ask you to slow down or repeat something as we go along. So firstly, I just want to understand again the statutory process when a building is proposed for listing. So from Historic Environment Scotland's point of view, could you talk me through and everybody else that process and what happened in this particular case?
Yes, thank you, sir. I think this might be one for Mr. Dowell.
Okay, so I see you have 2 separate agenda items though on that. So will I just roll into on what happened in this particular case and what we normally do? Is that okay? So I'll just go for it.
Thank you.
Okay. So there's a statutory duty for Historic Environment Scotland on behalf of Scottish ministers to compile a list of buildings of special architectural or historic interest, but there's no statutory process for how it's undertaken. The role of HES in compiling or approving lists of buildings of special architectural or historic interest is set out in Section 1 of the Planning Listed Building Conservation Areas Act 1997. Designation is undertaken by us. HES is a non-departmental public body and is the lead body for Scotland's historic environment. The selection of buildings for listing and the listing process is undertaken by staff within HES. Our functions in relation to listing are set out in the Historic Environment Scotland Act of 2014. There are no detailed statutory provisions for how this work is carried out in either the 1997 Act or the 2014 Act. And policy and procedure has been established since the introduction of the first legislation in 1947. And the most recent iteration of the policy and procedure which explains how we do our work is set out in the designation policy and selection guidance published in 2019. So I guess I'll just go ahead and say how we do our work. Our priority for designation is to provide an up-to-date understanding of sites and places to aid decision-making about potential change in the historic environment. For listing, our work informs decision-making done primarily through the planning system, but it also informs the sector more widely and helps inform decisions about grant funding or priorities for research, for example. We carry out our work by adding, amending, or removing statutory designations, listing, or making minor changes to existing designations. And we do this primarily by responding to external requests and also by undertaking projects, thematic projects, or developing partnerships with groups or participation of stakeholders. Any person or organization can request that we designate a site or place, or review an existing designation, or ask us to remove a designation. They can also ask us for certificates of intention not to list and to make minor changes to our records. So I'll just give you an overview of the application for listing and what happens when someone applies for a listing. There are processes that we follow, and then there's a number of steps that we take when we're asked to designate a building. So there's the application, there's the research and assessment, evidence gathering stage, there's a consultation phase, and then a completion phase, so it's a post-consultation phase, and then notification of a designation. So applications are made to us by submitting an application form, which we make available on our website. And when we receive that application, we publish it on our portal. In the course of assessing a site or place, we contact the owner of a building if we know who that is. And we also normally let the planning authority know and other parties who are affected by the potential decision that could take place. We would normally proceed with the designation review. In the course of that, sometimes we will maybe not proceed if we find that there are other mechanisms for designating the site, or not designating, but there are other things that could, say the building is not a building, it's a sculpture, it's a movable object. So sorry, that's a little side thing, but it might not be something that can be designated. So we look at that. So in the evidence gathering stage, we assess each site individually using the selection guidance, and the selection guidance for listing is published in our policy. Following research and that evidence gathering phase, we consider the merit of the building and we write a report. If the building that we've assessed doesn't meet the criteria for listing, and we don't intend to proceed for any other reasons, such as if there are development proposals, we will publish that decision and we'll let people know about that. So there's no consultation involved in that decision making if there is no statutory process that we're going to undertake. We just close the case. And we write to relevant parties for that. If the building meets the criteria and there's no reason for us to not proceed, such as development proposals at an advanced stage, as we're aware, we find the building meets the criteria, we propose to make a statutory change or to an existing designation, or if we propose to remove a designation, we consult. And so we normally consult with those directly affected by the proposed decision before taking that final decision. And this includes owners, occupiers, and tenants, and the planning authority. And we also welcome views from interested parties. We set out that reasoning in a document called a report of handling, and we publish that on our portal. The consultation period normally lasts 21 days. However, the scope and the level of participation in the decision-making may take longer depending on the circumstances of the case. And we're primarily concerned with views that relate to the cultural significance of the building or the special architectural historic interest. Although not a determining factor in the assessment of special architectural historic interest, we also consider policy what the purpose and implications of designation, meaning whether there are development proposals that might affect it. So that could take place at the consultation stage as we progress with the case. Following consultation, we consider the responses that are made, and we make a final decision about whether to list, remove a listing, or change the listing, amend the listing. And at that stage, there could be further discussion with owners or the local planning authority. So, we'll be in a phase where it would be after consultation. It might take quite a while before we come to a final decision if there's further matters to consider. We set out our summary of that consultation in a consultation summary in our report of handling. So we visit the report of handling to update it with what we've considered at consultation. And we publish that on our portal, and we set out in that document whether we've made any changes to the proposed decision that we made at consultation. So there can be, a change to what we originally consulted on. And then we reach a final decision and the formal confirmation of the listing, and that's a formal notification that we do undertake. So that's basically the process.
Thank you,
Some of them, are we going to talk about case and the timings and all of that?
No, I think what we're going to do, I think the overview is very useful, and that'll lead quite neatly on to my next two questions about the generality of the listing process, the designation process, and then we can come back to what happened in this case. Before I proceed with that, are there any comments from anyone regarding the general process of designation? Does everybody understand that? Yeah, Mr. Burnett.
I just wanted to clarify how HES view their document, which is lodged at HES 7.02. It's described there as the listing process, application types, process and notification. Is that guidance or just advice on how they go about it? They tend to follow that.
Yeah. I know. That's what I'm thinking.
We'll just pull that up and my business to speak to this if you give us 1 moment. Can you give us the reference again, please?
HES 7.02.
That's from our website.
Okay.
This is one link from our website. Its intention is to describe the process and provide skills help those interested in understanding how we do our work. It's a policy.
Mr. Burnett, you raised this document. Is there a particular part within it you want to draw my attention to, or?
Yes, sir. I was going to do it probably under E of your questions, but it's on page 16 of 30. It's just says there, review a listing decision. We will only review a very recent decision to list if there is good reason to do so. Such reasons might include, and then the loss of the building since its listing, or significant evidence not previously considered relating to the building's special architectural or historic interest. It's just whether that sort of consideration applies in relation to a decision not to list as well. I mean, it obviously comes under 2E, a second decision in relation to the same matter soon after a first decision.
Okay, let's take that question now. So any response from Hez?
The wording is decisions to list, and that's its intention.
Okay, thank you. We can come back to that, Mr. Burnett, if required under E. I think you said you wanted to review it. Let's move on to B, so discussion regarding the structural integrity and socioeconomics in relation to considering designation of the building. Those two matters, are they ones that HES would consider normally when looking to designate a listed building?
Again, one for Ms. McDowell.
Okay. Yes, we certainly what we take into account and what we don't take into account is noted in our policy in sections 14 and 15 of our selection guidance for listing. Our policy says the extent to which a building or structure survives is a consideration when assessing for listing. However, the present condition of the surviving fabric is not a factor when deciding whether it is of special architectural or historic interest. A building might be structurally unsound, but still be of special architectural or historic interest, and structural integrity will not impact on our assessment of special interest unless the degree of loss to the building's fabric has affected that understanding. A question we'd ask ourselves is, has the loss of fabric adversely affected the building's architectural historic interest and its ability to convey that interest? That's effectively what we think about that part of it. There are other things that can take that into account in terms of the wider wider policy, or the wider policy with the legislation that affects listed buildings. So if there is a structural issue where there's public safety as a concern, those would be dealt with through dangerous buildings, and listing wouldn't affect, would not prevent repair or demolition where that is urgent and where there's public safety at issue. And for that reason, structural integrity for us is not a concern for listing. And listing doesn't prevent a future demolition of a building where that might be a consideration within the planning, the consent process, listed building consent process. In terms of financial issues and social issues, the policy explains factors such as financial issues, proposed future use, or building not being in its original use will not be taken into account. And I think there's two things being asked. First, there are economic factors. Are they a material consideration for listing? And second, those social factors. Economic factors are not a consideration for listing, but form part of the listed building consent process, as I was explaining. Viewing the legislation as a whole system, it's clear that listed building status does not apply a future embargo on change subject to any necessary listed building consent or other planning or regulatory processes. The decision to list is taken in the context of our role in applying statutory protection to buildings of special architectural historic interest within that policy context and the legislative context. And this view has been supported consistently by Scottish government reporters for the previous building designation appeal decisions to date. I can tell you that we do take social value, social historical value into account as part of our assessment for listing, and this is set out in our selection guidance. The way a building contributes to our understanding of how people lived in the past and how our history is shown in a building or its setting is very much a consideration. Having set this out, specific value in context of an individual decision, I think it's important for me to refer you again to the wider policy framework, which has informed our designation policy and selection guidance. The Historic Environment Policy for Scotland provides a framework in which a designation policy was developed, and principles and policies such as avoiding intervening unnecessarily in the planning and other regulatory processes. And that reflects our specific role within the planning system and provides for a proportionate approach to heritage protection. So that I'm just trying to give you a picture of how what we do is we take individual decisions within the wider context. So there's a system out there that deals with, for example, the structural, the economics.
Thank you. So in this particular case, the matter of the structural integrity of the building, the fact that the appellant has suggested there might be a health and safety issue, and the fact that there might be socioeconomic benefits arising from the removal of the building, those were not, they were not considered in relation to the listing of the building. Is that correct?
That's correct.
So, and the reason for that is to do with the policy, which we'll come on to the status of that policy later on, but the reason for that is to do with the policy. It's not, as you said right from the outset, there's no statutory process that's laid out within the legislation or regulation to say how to designate a building. But in the policy that you've adopted, that's the approach.
I think that's right, sir. If I could just come in, I would just add to that the 1997 Act is clear to direct decisions on listing to a consideration of whether a building is of special architectural or historic interest. So that's certainly the overriding determination that HES are looking to make when deciding whether or not to designate. And yes, the policy, of course, has been developed to try and assist in the application of their statutory duty there, and to provide consistency of decision making.
Sorry, I have 3 screens, so whenever I need to unmute myself, I've got to move my mouse around, so apologies for any pauses. We're going to come on to that statutory footing in a second. I'd like to drill down into that. Before we do, Mr. Burnett, do you have any further comment?
Not in the generality, sir. I think we'll get on to the specifics later.
Okay. And obviously, Glasgow City Council, if you want to come in at any point, you're welcome to do that. Probably more interested in the building preservation notice, but anytime you want to chime in, just put your hands up. Thank you. Okay, well, let's move on. Let's look at the wording of specifically the Town and Country Planning Appeals Scotland regulations and those that were amended in 2015. And I want to look at, in particular, section 18A4. Does everybody have a copy of that? Yes. So what I want to understand is, if we read this out for anybody that's viewing this elsewhere, it says the notice of appeal may include as the ground or one of the grounds of appeal a claim that the building is not of special architectural or historic interest and ought to be removed from the list compiled or approved under Section 1 of the Listed Buildings Act. So there seems to be a nuance there, and I want to try and understand that. It doesn't say the only ground of appeal is that it's not of special architectural or historic interest. It says that that's one or maybe one of several grounds of appeal. Does that mean that the decision maker can consider other factors in determining whether or not to designate a building? I'll go to Historic Environment Scotland first. Thank you.
Thank you, sir. So I think in order to answer this question, we need to consider 3 things. We need to consider the statutory framework, and we need to have a look at policy, and we need to have a think about what the implications of the court's decision in Vice are. So if we start with the statutory framework, yes, as you say, sir, I would accept that the inclusion of the wording one of the grounds of appeal in the regulations there, that implies that there may be other grounds of appeal beyond the building itself not being of special architectural or historic interest. But I don't consider that this wording allows for open-ended grounds of appeal. I would submit that the regulations need to be read alongside the Primary Act, alongside the 1997 Act, under which they're brought into being. And as we've already picked up on earlier in discussion, section 1, subsection 1 of the 1997 Act is clear that the only relevant factor in deciding whether to list a building is whether the building's of special architectural or historic interest. And subsection 2 of that section, if you have that to hand, sir, that goes on to provide that in considering whether to include a building, HES may take into account not only the building itself, but also 2 other factors, which are enumerated as A and B, A being any respect in which its exterior contributes to the architectural or historic interest of any group of buildings of which it forms part, and B, sorry, 1 and 2, B being the desirability of preserving on the ground of its architectural or historic interest any feature of the building consisting of a man-made object or structure fixed to the building or forming part of the land and comprised within the curtilage of the building. So I think when the regulations are read in that context, in the context of the primary legislation, I would consider that the implied reference to other grounds of appeal beyond the building itself not being of special architectural or historic interest is a reference to those other aspects of architectural and historic interest which are set out in the primary legislation. In my view, it would be nonsensical for the relevant considerations in the appeal process to be broader than the relevant considerations in the listing process, in the initial listing process. And I don't think there's a foundation for any finding to the contrary. If Parliament had intended for additional factors to be relevant to the appeal process, I think they would have used explicit wording to that effect. And as far as I'm aware, all the appeal decisions to date have restricted themselves to a consideration of whether the building in question is of special architectural or historic interest. And I would commend that consistent line of decision makings to you, sir. So that's my view on the statutory framework. As we've mentioned, the statutory framework is light, and HES have introduced policy in order to help with the application of its duty there. So regard has to be had to the relevant designation policy when you're reaching decisions, just as a matter of public law. And I'm sure we're going to drill down into that policy and the interpretation of it later on in the session. So I don't propose to go into that now unless that be of assistance. And then the final consideration is, what are the implications of the court's determination in Vice, in the court session case, which is before you. And I think we need to be clear as to what exactly was before the court there. So I don't read Vice as deciding on how the designation policy should be interpreted. That question wasn't before the court. The court wasn't addressed on matters of policy interpretation, and the policy itself wasn't being challenged. Historic Environment Scotland weren't there at that. They weren't in the process. They didn't speak to the policy. The court, in my view, didn't decide that complaints of procedural fairness are valid grounds of appeal under Section 5B of the 1997 Act. In my view, what the court did do is it considered that the reporter in that previous case in 124 Craighall Road had failed to address a central issue in the appeal, namely a complaint about the unexplained change of view on the part of Historic Environment Scotland. And in order to address the court's concerns, a reporter would need to understand, interrogate and opine on the approach that HES took to the previous decision. But whilst being a central issue in the appeal, in my view, it shouldn't be determinative of any appeal. And any conclusions on procedural propriety of past decisions shouldn't influence the ultimate determination of the appeal. That seems to me to be the appropriate way to give effect to the court's decision. It's taking cognizance of the statutory and policy framework in which a decision falls to be reached on this appeal, in which a determination has to be reached. And I think it goes back to what the role of the reporter is here. And I would suggest that your role is to reach a fresh determination on the merits. You need to decide whether the building's of special architectural or historic interest, and whether the designation of the building would accord with the Historic Environment Scotland policy. And it might be helpful in that regard to consider the analogous position of appeals under the Principal Planning Act, under the Town and Country Planning Scotland Act 1997. If a planning decision is appealed under that act to a local review body or to the Scottish ministers, that new decision maker has to reach a fresh decision on the merits of the appeal. And there's no ability at that stage for a decision to be reached based on procedural flaw of a preceding decision. that's not a determining factor in disposing of the appeal, and I'd suggest the same must be true here. Hopefully that's of some assistance, sir. I'm happy to take any questions.
Yes, thank you for that. I've taken those notes down. Now, I am interested in this in the sense that I've got in front of me the Primary Act, Section 1.1 and 1.2. Now, in there, it does mention buildings of special architectural and historic interest. But am I taking it, Mr. Gregg, that you're saying that 1.2, where it lists A and B, those are the only two additional factors that you think can be considered?
In terms of the statutory framework, that would be my view, yes, sir.
But does it omit any others? Does it prevent you from considering other factors?
I think if Parliament had intended for other factors to be relevant to that process, then explicit wording would have been used. So, for example, when determining planning appeals, they are determined in accordance with the development plan unless material considerations indicate otherwise. So that introduces the development plan and material considerations as relevant factors in that determination. We don't have any similar wording here.
But I mean, forgive me, I'm not a lawyer, but in terms of common law, would you not consider other material factors in decision making?
My view is that when determining an appeal under this legislation, you need to consider whether the building's of special architectural or historic interest. You need to consider the two factors identified there at 1.2, and you need to consider the HES policy, designation policy, and whether a designation would accord with that. I don't see any grounds for introducing any factors beyond that. And certainly in previous appeal decisions that have come before Scottish Government reporters, that's the grounds on which these decisions have been made. And I'm not aware of any other appeal having been decided at the designation stage on the basis of any other grounds or considerations. It's to do, I suppose, looking at the bigger picture. This is one step in the statutory process, and there is, of course, as Ms. McDowell was explaining, the listed building consent process, which is a broader, in which broader considerations are at play.
Okay, thank you. And in terms, I assume that the question of fairness, procedural fairness, which you raised, Mr. Gregg, again, my understanding is that might come from common laws. Is that correct? And from what you've said, I assume that you're saying that that wouldn't be a factor I could consider.
That's my view, certainly, sir. Yes, it's certainly true that that public bodies need to make decisions in accordance with these public law principles, and they can't make irrational decisions. They can't take into account relevant considerations, the usual public law grounds. And if they do, they're amenable to challenge in the courts. But it's the courts that have the power to judicially review a decision of a public authority. It's the courts that are empowered to dispense appropriate remedies to quash decisions. A reporter doesn't have that power. So I don't see a reporter having the ability to legally review or to review the legality of a decision that went before it in a determinative way.
Okay, we've covered some ground there. Mr. Burnett, would you like to come in and reply?
Yes, thank you, sir. I think in your previous hearing, there was an issue as to the jurisdiction that you had, whether it was of review or of a de novo merits appeal where you could decide the merits. And in my submission, that's what this section or regulation 18A4 is directed towards. It makes it clear that you do have the remit to look into the merits of the decision. And when it says that the notice of appeal may include as one of the grounds of appeal a claim that the building is not of special architectural historic interest, that clarifies that you can get into the merits and it's not merely a review of the decision that's already been taken. You must mention that's why that is there. In terms of Section 1 of the 1997 Act, I would say that while it identifies the primary considerations that have to be taken into account by HES in reaching its decision on whether to list or not, it's not exhaustive either. And as a general principle, a public authority should take into account other factors. And in fact, in my submission, we'll come on to this, but HES's own policy and what they did in relation to Decision 1 clearly shows that they took into account the effect on the owners and others and the advanced stage of planning proposals. And that's clearly within their own policy. And that shows that there are other matters other than the pure architectural interest or historic interest of the building that are relevant to the listing and which both they and you should take into account in reaching the decision. And the Vice case makes it clear that the reporter has to look in also to the procedural fairness of the overall process as one of the aspects in deciding the appeal. It's clear the court found that the reporter should have taken into consideration the appellant's submissions in that case, that the process had been unfair and there was no explanation of the second decision in light of the first decision. And that was a procedural unfairness that the court recognised and sent back to the reporter to take into consideration. So the reporter was directed, at the very least, to take into consideration that factor in the second decision. So it's open to you, sir, to do the same, to take into account all the circumstances.
Thank you, Mr. Burnett. Mr. Gregg, would you like to come back with anything?
I think you have my submissions on the points, sir, but happy to take any questions. To be clear, I think that any determination of the appeal by yourself needs to be on the basis of the statutory framework and on the basis of the policy. Statutory framework, in my view, on a question of statutory interpretation, doesn't permit any factors beyond whether the building's of special architectural or historic interest. And those factors listed in Section 1 of the 1997 Act, you can certainly have regard to the Historic Environment Scotland policy and compliance with that. And I don't read Vice as requiring you to, I think Vice, I would say, certainly requires you to have regard and to understand and to interrogate it. You can opine on the head's decision-making that went before, but I don't think that can be determinative of the appeal before us.
Interesting. Just what would be the point then in me having regard to and interrogating the decision-making process if I wasn't to take it into account?
I think it would just be in order to ensure a fair hearing for all parties, but your remit is not to review the legality of the previous decisions. So I would suggest that if you can take it into account and comment on it without it influencing your final determination, that would be sufficient to satisfy the courts.
Okay, and let's just, for hypothetical reasons here, say that I came to the conclusion that the process was unfair, and then, but the building was still of special architectural and historic interest, then your reading off it would be my conclusion should be the building remains designated. Is that correct? And then the remedy would be through the courts?
Yes, that's right. I think if there was, I think the statutory appeal mechanism that we have from the decision of Hess to Scottish ministers is a particular one, a restricted one, is set out in legislation. That original decision by Historic Environment Scotland could theoretically have been amenable to judicial review, perhaps. That's a different question. And it would be for the court to review the legality of the decision-making that had been undertaken in that instance. So whilst it's a central issue, I don't think it's determinative in the particular remit that you have as a reporter appointed to consider a statutory appeal. I would consider legality of decisions to be a matter for the court. And it is the court who's empowered to distribute the appropriate remedy, whether that's to quash the decision or whatever they might consider appropriate.
Mr. Burnett, any further thoughts?
Other than I don't completely understand the coherence of HES's position on that. If it's referring to judicial review of the first decision, that would presumably only be by an interested party or a Glasgow City Council, because the appellant here was content with the first decision and has a statutory right of appeal that's exercising now in relation to the second decision, which is the contrary decision. So that's what I say in relation to that. But in my submission, you do need to take into account the fairness of the procedure. And while having decided in the hypothetical that the process was unfair, you then have to take the decision afresh. One of the factors that you take into account when retaking the decision is that procedure that's been followed, the unfairness of it and the consequences of that. And that, in my submission, would be in line with HES's own policy in relation to looking at the consequences and the advanced stage of development and the proportionality of the decision, its consistency, transparency, etc. So it is a relevant factor in your redetermination if you decide you require to redetermine the decision.
Now, Mr. Gregg, Mr. Burnett raised the point about the fact that HES does take into account other factors, and the example being given was that where development proposals or other regulatory proposals were at an advanced stage. Does that run counter to your argument that we can only consider the special architectural and historic interests of the building?
I don't think so, sir. I would see them as, you've got the statutory framework and you've got the policy, and the policy is there to assist with the application of the statutory framework, and they sit side by side. So certainly you could take into account factors that are outlined in the designation policy, and that would be an appropriate way to proceed in reaching a determination.
Right. Any further comments with regard to the statutory instruments? No. Okay. We'll move on to point D. So, Ms. McDowell, if you wouldn't mind just explaining what happened in this process. Was an individual that came forward and applied for the designation of the building. and then just talk us through your process. When did you consult with the owner? Did you do it in both cases? Well, we're just talking about the initial application just now. So talk me through that process. Thank you.
Okay, so we processed and managed the case in our usual ways, as I explained, and we set that out as well in our response to appeal. We first received an application from a member of the public to list the former cinema in July 2023, and the application was validated and published on our portal. As part of that validation process, we compiled initial information about the location of the building, some basic historic information, and we checked the planning portal for the Glasgow City Council planning portal for any development proposals that might affect the building or the site. And that's what we do in all sort of initial stages of a case. No development proposals were identified, and at this initial logging stage. Over the course of between July and October, we contacted the planning authority and the owners to inform them of listing proposal. We didn't know who the owner was. It took us some time to find out who they were. And by October, we were able to make contact. We do sort of register search, and that's, sort of how that came to light. So we contacted the owners at that stage. During the course of our assessment, we considered whether a site visit was necessary. And in doing so, we corresponded with the owner, and they sent us recent photographs of the building's interior and exterior. And that's something that we do with most cases where we seek to find out information from the owner about the site and ask them about, whether they have information about alterations and things that have gone on, and sending photos is common. So towards the end of 2023, as we neared the completion of the research and evidence gathering stage, we decided that we would like to visit the site and made arrangements with the owner. And this was planned to take place in the middle of January 2024. And we also wanted to take the opportunity to formally record the building so a record could be made for the National Record of the Historic Environment, because we understood by that stage, by that date, that the building warrant for demolition had been approved. And that was 22nd of December 2023. So from contacting the owner to sort of doing more research, finding out about what the building looked like, and then there was sort of an understanding that there was potential for us to come to a conclusion to our decision making a bit faster than sort of waiting till January. So we decided to visit the site independently before the proposed date of visit later in January. So we went to the site and viewed it from the public realm on the 4th of January. Because we had also been informed that there was a contract potentially for the demolition. So the demolition was, although approved, we didn't know when it was going to take place, but we had been informed that this demolition could probably take place imminently. So we went to visit on the 4th of January. We decided, following our visit and all the research that we had gathered, that we had sufficient information to take a view, and found that the building met the criteria of special architectural historic interest, and that category C was the appropriate level of listing for that building. However, because the building warrant was in place, we decided, in line with our policy, that we would not list the building because the development proposals affecting it were advanced. And we published a decision on the 12th of January, and in the form of a report of handling, and we informed the owners and the planning authority and the proposer of that decision. And in that report, we referred to the possible VPN being served by the council, because at that stage we had understood that that was a potential. And we said specifically that we would take a separate decision if that notice was served, and that's in our report.
Thank you very much. Just the appellant, I'm trying to understand the timeline here. So, am I right? The list request came in January 2023.
July.
July, sorry, July. That's what I have written. July 2023. And the application for a building warrant was November 2023. Is that correct?
I think that's correct.
Okay, and then it was granted in December 2023. Okay, so the appellant was aware of the fact that you're saying you made contact in October, you managed to find who the owner was in October 2023. Yeah. And then the month later, the appellant applied for demolition of the building in the knowledge that someone had asked for it to be listed. Is that correct, Mr. Burnett?
I'm going to ask Mr. McConville to answer that, if that's helpful.
Hi all. Yeah, just on the 16th of October, there was an email sent in, but it was blocked by our firewall. Then I received a call on the 13th of November from Historic Scotland regarding that email. And between the 13th of November and, as Don said, up until the 1st of December, there was a couple of emails and conversations looking for internal and external photographs. That was passed on. Then on the 21st of December, received an email asking for a site visit. We explained, due to the festive period, more than happy to show everyone around when we come back from the break. So it was agreed the week beginning the 15th of January to meet and go round the site. And in fact, when we returned, we invited them in on the 9th of January, saying we can escort them round sooner. But Historic Scotland said we'd keep to the date beginning the week the 15th, and we can go round to the 18th. So basically, the first conversation was on the 13th of November, and that was up until, as Don says, up until the January, up until the 12th of January, when we received the email notification letter saying the designations report saying we're not proceeding with designation at this time as development proposals were at an advanced stage.
Sorry, thank you very much for that. But just to go back, so 13th of November, you said your firewall blocked correspondence in October. By 13th of November, you were aware. When exactly was the application to demolish the building then? Was it before that or was it after that?
A building warrant for the demolition was on the 21st of November 23, so after that.
That's the warrant being granted.
That was the one we granted, and that was all down to the demolition company who had the contract in September.
Yeah,
I believe the contract was awarded to the demolition company, so it was them that organised all of that.
Yeah, I don't know if you can hear that, sir. Mr. Messina saying that the contractors were engaged in September, and they were the ones who submitted the demolition application. So plans were already in train before that. And it wasn't the appellant itself that submitted the demolition application. That was the contractor who'd already been contracted to undertake the demolition.
Super. Okay, thank you. That makes sense. Unless there's any other comment on that, we'll move on to E. So very swiftly, just to confirm that the initial decision, that did not limit the issuing of a building preservation notice.
Sorry, sir, just one. Ms. McDowell, I think, has something to add on the previous item, if that's all right.
Oh, sorry, it was just to clarify, a phone call was made to Allied Vehicles on the 16th of October, and we were able to contact them then, and then we asked for contact details to send an email, and I just wanted to confirm that, yes, that we did send an email, and then it was the 13th of the 11th, so, but there was contact made in October.
Thank you. Now, sorry, someone's dropped off the screen. Oh, there we are. It's Glasgow City Council. So just let them back in. There we are. So just back to that building preservation question, your initial decision, that doesn't limit in any way the issuing of a building preservation notice, is that correct?
No, there's nothing in legislation or policy to say that the further review could not be carried out and that a BPN couldn't be served. There is no procedural reason for a BPN not to be served. And we certainly made that clear in the report of handling.
Thank you. Now, Glasgow City Council, are you there?
I can hear you, Mr. Edwards, but we can't see you. Can you hear us?
Oh, I can. You're kind of flickering on and off, but we can hear you. Brilliant. So
sorry, we lost the signal for a moment there, and would like to just clarify something that was just being discussed, which was the timing of the application for the building warrant for demolition and the granting of that, because we thought it was an inaccuracy being stated, which was the building warrant was applied for on the 22nd of November 2023 and granted around the 22nd of December 2023. So we just wanted to make sure that you were clearly aware of the timeline there. Unfortunately, technical hitches have got in the way of us communicating that to you.
no problem, thank you. Now, I'm going to ask Glasgow City Council, could you just take me through the process of issuing a building preservation notice? What happened in this case? Do you have a scheme of delegation for building preservation notices? Did it go through a committee process? Did you get the first report of handling from HES? You reviewed that and then you thought, we're going to serve a building preservation notice. You just talk me through that process.
I'll clarify that, first of all, in terms of the scheme of delegation functions, this is an officer-led decision. It's not one that requires a committee approval. So really it's for officers in the planning section to make a call on whether or not, in all the circumstances of the case, considering where a development has reached and whether or not a building preservation notice is to be served or not. In this particular case, I think the Council's planning section was made aware that the Historic Environment Scotland had designated this building as being of special architectural and historic interest, but they were not at that time going to issue a listing for the building. So that meant that Glasgow City Council had to make a decision as to whether or not, in those circumstances, they wanted to introduce a building preservation notice to protect the special architectural and historic interest of the building. But what I'll do is leave it to one of my colleagues to explain the actual detail of what happened in this particular case. That's okay.
Thanks, Martin. So as Martin's outlined to you, we obviously received HES's initial decision where they were clear that, in their opinion, the property did merit listing in that it was of special architectural or historic interest, but that, as we have discussed, they would not list it at that time because of development proposals, i.e. the warrant for its demolition. So in effect, that demolition warrant, we had to think about that and viewed that to be in accordance with the process for issuing a BPN, in that A, the property is of architectural and historic interest, and B, it's clearly in danger of imminent demolition or alteration in such a way as to affect that character and special interest at that time. And so we had to make a decision at that point as to whether we should issue a BPN. As Martin said, that's not a committee process, and our head of planning took cognizance of all the matters in front of her and recommended that we should serve a BPN to afford the property temporary listing in effect, so that HES would then reach a second decision, as it were, as to whether or not the building should be listed.
Okay, I feel like that my questions here, the statutory process, why Glasgow City Council issued a BPN following the HES's initial decision, and why it was issued almost immediately after granting a building warrant. They're all kind of together, so we'll talk about this in the round. Firstly, I want to ask, you said it's scheme of delegation, so it's officer decision. So what about compensation? Is that something that's considered by officers, or is that not something that should be considered by a committee?
Basically, this is not a regular occurrence within Glasgow City Council. I don't know if we voluntarily issue building preservation notices off our own back. I don't think we've ever done that, as far as I'm aware. I think what was apparent in this case is that there was a building of special architectural and historic interest, or historic interest was in danger of demolition. And in terms of our scheme of delegated functions, whilst there could be compensation flowing from that decision, there had to be a weighing up of all the factors by the head of planning before a decision was issued in terms of issuing the building preservation notice. One of the things I would like to clarify, however, was it at an advanced development stage? The council would respectfully disagree. It wasn't at an advanced development stage. There was basically only a building warrant for its demolition. There was no planning application in place. So the council had no idea currently what was to happen to the building after this facade was to be demolished. So there was only a building warrant for its demolition in place. There was no planning application. The issue of compensation in those circumstances becomes less important, I would say, because what is the planning application that is being thwarted by the building preservation notice being issued? So it's an easier decision for our officers to make.
Well, that I suppose is the point I was trying to understand was, so when the initial decision came out, that gave the council confidence to issue the building preservation notice because the risk of compensation had almost disappeared. Is that correct?
I would say that is correct, Mr. Edwards. The point is that the council, when it got the first decision, still had to weigh up what was in play in terms of its planning function against its heritage function. And in terms of its planning function, was there a development proposal on the table? No, there wasn't. There was only a building warrant for demolition. The council looked at it in the round and decided in these circumstances they were comfortable issuing a building preservation notice.
Okay, well, let's step back slightly. So I want to understand more about this building warrant process.
Yeah.
So first and foremost, the planning department where the listed building specialists sit in the council, is that department combined with the building warrant or building control section of the council?
They are linked, but just to clarify, when an application for a building warrant demolition comes in, there is no requirement or no natural checking with the planning section as to whether or not that should be issued. There are separate functions, separate officers doing those things. And so on your agenda, that is why did we issue a BPN after a building warrant had been granted, or a demolition building warrant had been granted. The point is there is no direct crossover. There's a decision making, the carrying out the building control function independently of our planning function.
So, and this is just what I want to clarify, so let's go back to my initial question. Do building control and planning sit under the same director?
They sit under the same director ultimately, as you know, there's loads of different departments within council, yes, but the management of the building control function is by a head of service, and that is a equal head of service to the head of planning. So the head of planning basically is a grade 10, the head of building control, is a grade 10 within the council. So they're two independent sections. Ultimately, they will answer to the same director within neighbourhoods, regeneration and sustainability. That's just how the council divides up on functions.
So I'm just trying to, forgive me, but I need to try and understand what's happening from Glasgow City Council's point of view. So someone makes an application for a building warrant to demolish a building. Now, there's several factors here. If it's a listed building and you apply for a building warrant to demolish it, does someone in building control not say, hang on a minute, you need consent to demolish this separately? Or if it's an unlisted building in a conservation area, does someone flag it? I'm just trying to understand, is it completely separate and the building control officers don't talk to the planning officers?
Yeah, it's completely separate, Mr. Edwards. They have no remit to inform planning colleagues that they have an application for a building warrant. It's completely separate legislation and separate processes, and one does not interfere with the other. The onus is on the applicant to ensure that they have all the necessary consents in place. So if it were a listed building, naturally they would also require a listed building application for demolition to sit alongside a building warrant, but one is not dependent on the other.
Okay, and
one is not dependent on the other.
Sure, and I'm aware that there isn't a building control officer in this hearing, but I just wondered, there isn't a checklist then when you apply for a building warrant, this doesn't get flagged, it doesn't come up and say, should you demolish this building?
No, it would have made no difference anyway, as far as my understanding of it is, in terms of the application for the building warrant. The fact that this building was being assessed for listing is of no consideration to building standards officers in terms of their dealing with and issuing their determination of that application.
Okay, so what I've ascertained is an application for a building warrant was made by the contractor in November 2023. That went to a separate function of the local authority, and they processed it separately, and no one else was informed that they were granting permission for demolition of this building through a building warrant. Is that correct?
Came to light much later. It came to light and before we granted it. So we were only informed by a third party. So we sorted our IT issues at this end, so I'm different side of the table now. Yep. So the heritage team within the planning service was made aware of the building warrant by an external third party to the council. We weren't made aware by our building standards colleagues, and we weren't made aware of the building warrant until late December.
Okay, so, right, the planning service was informed by an external body, an external person, that another arm of the council had approved demolition and that demolition work was taking place. Is that correct?
They hadn't approved the demolition warrant. We were made aware on the 20th of December 23. The planning service was made aware of the building warrant application on the 20th of December. Our building standards colleagues, under their legislation, as Martin has now made us aware, that there's actually the regulations are that building standards must issue the building warrant. So they were unable to not issue a building warrant for demolition, and they did so on the 22nd of December 2023. The HES came to their first decision and they issued the DPA was after that.
Okay, so just getting this clear in my mind. 20th of December, the planning authority is made aware that there's a building warrant that's been applied for. And because of the legislation, your colleagues in building control had to issue the building warrant 2 days later.
I think, just to be clear, it wasn't, as far as I understand it, Mr. Edwards, the building control team that made the planning team aware that there was an application.
Okay.
That came through some other interested party, and I'm not even sure who that was. At that point, the planning heritage colleagues contacted the building warrant team to discuss the application, but were informed that, and if the criteria were met for issuing the building warrant, it was a must. It wasn't a may. There was no discretion. So that's under Section 9 of the Building Scotland Act 2003. A verifier must, on application for a building warrant, be to grant a building warrant, but only if it's satisfied as to matters specified. So effectively, when the building warrant officer looks at the application, if it ticks all the boxes, the building warrant for demolition must be issued. But going back to my point there, it wasn't the building warrant team who contacted their colleagues in heritage planning. It was a third party, which led to a discussion, could they do anything to delay the issue of the warrant for demolition? And the answer was no, because in terms of the separate legislation, the Building Scotland Act, the building control officer, their hands were tied. They had to issue the building warrant for demolition because all the boxes were ticked.
Okay, so 20th December, you're made aware that the building is at risk of demolition, and somebody phones your colleagues in building control and they say, look, we've got no power here other than we have to issue the building warrant, and we're going to do that in 2 days' time. But you don't issue the building preservation notice despite the fact that you have delegated power to do so until the 15th of January, by which time demolition has already occurred on the site and removed the interior of the building. Is that correct?
That's correct. I don't think we would issue a building preservation notice without having a first initial decision from Historic Environment Scotland regarding their position as to whether it merits listing.
Well, I don't understand that. I thought the building preservation notice statutory power was for the planning authority to decide, as you said, if a building's of special or historic interest and is in danger of demolition, you can serve a building preservation notice. So why did you need to wait for HES to tell you that it had special interest?
Historic Environment Scotland are the national expert on whether a building merits listing, so we would be unlikely to move to that position without them stating that it merits designation.
The council were obviously aware that HES were looking at the characteristics of the building from October of 2023. So for the council to jump over the national expertise on it was probably not where the council wanted to be.
We're very aware that the building may merit listing, but we don't have the in-house expertise in the same way as the national body of Historic Environment Scotland do have that expertise to say whether or not a building merits listing.
But Glasgow City Council has its own specialist historic environment team, is that correct?
Yes, we have a small team headed by Alison. We don't routinely undertake the type of extensive research that Historic Environment Scotland do.
Well, that's what I'm trying to understand. You wouldn't need to understand. You would only need to think that building appears to have special architectural historic interest. It's in danger of demolition. We'll serve a building preservation notice and we'll let HES decide, because that's what the building preservation notice does. It gives HES 6 months to determine whether or not the building should be listed or not. So I don't understand why you needed HES to tell you, we think it's a special interest, before you could serve a building preservation notice.
I think in practice, that's what we would expect to happen, is that we would have that level of comfort from HES, and that might mitigate risk to the council. And in this case, obviously, HES were already actively assessing the building and had been doing so for quite some time. And as we understood it, would be submitting their report imminently.
Okay, so, and in the interim, the appellant had their building warrant, and so they were allowed to go ahead and start demolishing the building, which they did, for a period of over almost 3 weeks. So at that point, the building was no longer in danger of demolition. It was actually being demolished. Did that have any consideration for you when you were thinking about serving the BPN?
Yes, it clearly added an element of urgency to our response and consideration of what we would do in those circumstances.
And I realise that I'm pressing you hard here, but it's just so I can understand this. That element of urgency, the fact that you didn't have to go through a committee, the fact that you had delegated power, the fact that the Historic Environment Scotland would review a building preservation notice, but you waited. That's what I'm trying to understand. Why?
So routinely goes around the city making assessments of whether buildings are of special architectural interest. I think that's the context. We don't routinely have the resource to go through the city checking out whether or not there are buildings of special architectural or historic interest that require BPNs. That's just not what happens, unfortunately. We would love to have that resource, but we don't. So really what we have is a team who are embedded within planning who deal with a whole load of other things. And it's when we become aware that Historic Environment Scotland are interested in the special interest and historical characteristics of a building that we start sticking up our heads and taking notice. In this context, what happened here was we were aware HAS were interested in designating this building. They came eventually, as you understand, with a conclusion that it was of special architectural and historic interest, but because of the advanced development stage that the building was at, they were not going to list the building at that time. And I think that was the trigger for the team at that time to say, well, we have it confirmed by the national experts that this building is worth saving, we need to do something, but actually let's consider all the planning and other items that may be on the table before we issue a BPN. And it was the HES decision one that was the trigger for us to seriously focus on this, to think, hang on, we need a BPN here. And that's what happened.
Okay, no, I understand the process. So let's take a step back now and let's think that you're the appellant. Okay, you understand, you've contracted someone in September, you've taken ownership of this building, you've contracted someone in September 2023 to demolish the building, to presumably take forward some development proposal in the future. The contractor's applied to the council. It doesn't understand perhaps that there's a distinguishment between planning and building control. It gets permission to demolish the building, starts demolishing the building, and is then told you need to stop demolishing the building now because we're listing it. Does that sound like a fair process to you?
It sounds like a fair process if what was happening is that as far as we could see, that the developer or the owner of the building was aware that there was historical interest that still went ahead with applying for a, even though there was, you have to accept that the timeline was that by the phone call, an email before a phone call on the 13th of November, that the owner was aware that there was historical or special architectural interest in the building. But then after that applies for the warrant for demolition, we, don't want to get into a finger pointing exercise here, it looks like there's a way of the developer attempting to defeat the sort of protections that are in place to preserve special and historic buildings. So was the full process fair? We think so.
Okay, we've covered a lot of ground there. Mr. Burnett, I'm going to ask you to come in, and then we'll ask the question about whether what the BPN meant for the. In fact, no, I'll let Mr. Burnett come in, and then we'll take a break, and we'll come back and look at the second decision. So, Mr. Burnett.
Yeah, there is quite a lot in that, sir. I think if we go even further back, one issue you seem interested in is the council's awareness of proposals for the site. And my understanding is that there had been initial discussions with the council as far back as 2020, 2021, 2022 about possible redevelopment of the site, and discussions with Patrick Flynn, the head of regeneration. So the fact that there might be proposals on this site were not completely new to the planning department, but of more importance is the chronology of matters here. The individual apparently applied to HES in July 2023, and HES started their process then. My understanding from what Ms. Dowell said is that HES would have contacted the council as well as part of their research into the building at some time between July and December 2023. So the council should have been aware of the possibility to list the building at that stage. It seems that the council are playing in their own aid a miscommunication or lack of communication between their own building operations department and their planning department. And they seem to misunderstand the whole point of a building preservation notice, which, as I think you've been indicating, sir, is clearly to put a stop to matters, to allow time to be bought for HES to consider whether a building should be listed or not. That has happened already in this case between July 2023 and January 2024. HES have had their full 6-month period, and their conclusion comes with the issuing of the first decision notice that it should not be listed. The council's position makes no sense as to why they wait until that decision is issued before deciding whether or not to serve a building preservation notice. The time to serve a building preservation notice is when they're aware that there might be a demolition of the building or development of it. And that was when HES first contacted them, perhaps in October 2023, or certainly they should take steps to alert their building department in relation to that building if they consider it may be one that becomes listed prior to the application or between them becoming aware of the application in November 2023 and their decision in December 2023. That's the point when they're absolutely aware that there's a proposal to demolish the building. And if they're going to serve a building preservation notice, that's the very last stage at which they should do that. And they haven't done that. They say today that they're waiting to see what HES's view is. That is completely circular and pointless to then, having received HES's view in the first decision that it's not worthy of listing, to then serve the building preservation notice after they've already got HES's view. And it seems to be based on an understanding between the council and HES that they will change their decision just because a building preservation notice is issued. And the whole point of building preservation notice is merely to give HES time to take the decision, and they had time to take the first decision, and they did. And my submission, that's what the end of the matter should be. It's not a second chance to reconsider the matter after that.
Okay, is that yourself done, Mr. Burnett?
I think for the time being, sir, we'll obviously come back to this in terms of policy decision, etc. But overall, I completely refute the suggestion that it's a fair process when the appellant has validly applied for and been granted something, and then not even immediately, but after a decision which also is consistent with them being allowed to demolish it, a new process is started.
Now, before I come back to the council, I think it'd be interesting from Historic Environment Scotland's point of view to tell us about building preservation notices. Is this the usual process that HES makes a decision not to list, a building preservation notice is then served, or is it the case that, and I realise that these are fairly unique, but that a BPN is served and then HES assesses the situation?
Sorry, sir, can I just add one observation before HES goes on to that? But I think Mr. McColgan referred to they don't voluntarily issue BPNs. And that doesn't make any sense to me. And he also refutes that this was at an advanced stage of development. In terms of development that the Act is referring to here, or the policy is referring to, demolition commencing is obviously a very advanced stage of development. If you're talking about looking at the effect on a listed building, it's the most advanced stage it can be. It's starting to demolish the building.
Thank you. I'll ask Hez to come in, and then I'll let Glasgow City Council reply.
Thank you, sir. I'll pass over to Mr. Parsons to address any questions you might have, but just a couple of points from me. Building preservation notices, obviously, service of those isn't a matter for Historic Environment Scotland, albeit that if they're notified after one is served, then they have policy in place, and no doubt will come on to discuss the particular policy that's set out in the designation guidance, the interpretation and meaning and application of effect of that later on in the session. As you correctly point out, they are quite, well, very unusual, I think it'd be fair to say. There's not many building preservation notices, as I understand it, that have been issued for a good number of years. Albeit I do appreciate that you have 2 cases on your desk at the moment. But yes, I'll pass over to Mr. Parsons, who might be able to explain the process.
Thanks. I think, Mr. Edwards, your question is about what then the normal situation is, and as Mr. Gregg has just said, I think it's hard to kind of set out what a normal situation is. We could set out what happened at 124 Craighall Road, which you're aware of, and that was, I suppose, a relatively recent context. Prior to that, as I understand, we're going back nearly a decade to the last building preservation notice in Scotland, and prior to that, there's another gap. They happened in fairly regularly in the 1980s and 1990s, and not so much after that. So it's hard to set out what we consider to be the normal context. Certainly, this is what happened at 124 Craighall Road. So that, yeah, we haven't set out a procedure for this. I'm sure the council doesn't either have a procedure for it, and that reflects the relative rarity, notwithstanding the other case, but the relative rarity of this process.
In terms of, and I don't mean this to sound crass, but your Historic Environment Scotland, you employ, I guess, professionals. They have IHBC accreditation. Is that correct?
Not exclusively. Many people, we have a set of different types of experts, but yes, many of the team do.
Yes, yeah, but as part of that, you delegate some of your decision making, as it were, advice to certain councils, or in terms of certain cases. Is that correct?
I don't think delegation is the right term for this. No, you might be referring to an older procedure which predates Historic Environment Scotland. That related to a notification of decision making. So since Historic Environment Scotland came into being, we have.
Sure, I think to put it another way, does Hez have confidence in Glasgow City Council's heritage team?
I don't think that's a question I can answer here. We work closely with Glasgow City Council. I wouldn't express a view about the council's heritage team.
I'm just what I'm trying to understand is why Glasgow City Council needed the reassurance of Hez to make the decision to serve a BPN.
I think the council have answered that for themselves. Okay. We don't have an opinion on that.
Okay. Right. Glasgow City Council, do you have any response?
Yes, thank you, Mr. Edwards. Just to be clear, Mr. Burnett said we don't voluntarily. That's not what I said earlier on. not as a matter of course does Glasgow City Council go out and issue BPNs, because it's just not, as Mr. Parsons has highlighted there, they are so rare. Okay, but I wouldn't say we are negating the statutory responsibility that we have. We just don't do it that often, which I think a fair way of continuing. In terms of the awareness of the demolition proposal, that only became aware to the team Heritage around late December of 2023. Before that, there was no demolition proposals. I don't know if colleague Alison wants to fill in any further detail of what she's heard so far and how she'd like to respond.
I think what I would comment on is that in terms of serving BPNs, as Martin has just said and as Dara has also indicated, it's a very unusual circumstance and a very unusual situation, and certainly we would not be in the business of, when we are notified of a listing assessment that's been sent to HES, we receive many of those week to week. And we certainly would not routinely then allow that to trigger a consideration or issuing of a BPN in order to safeguard that potential historic asset from potential demolition, someone putting in a demolition warrant under building standards legislation. So, you know, that's just not something that we would do. I'm not sure whether it's relevant, but just for comparison, in England, in terms of this sort of situation, I believe that a BPN is only ever issued by a local authority there, where they have received a consultation from Historic England that gives them that expertise and that level of comfort that that particular property is potentially of historic interest. Unfortunately, that's not the case here. And in terms of the planning history of the site, whether there were meetings, nothing was recorded in the planning history. So there were no formal pre-application or live planning applications for the development of that site. And so effectively the only advanced development in terms of HES's interpretation was this demolition warrant that was ultimately granted towards the end of their assessment, which, you know, began back in the July of 2023. And I think it's perhaps also relevant that the timing of the thing, the council does shut down for 2 weeks over the festive period. So, you know, bear in mind when this all occurred, we were about to stop for the Christmas period and not returning until, I don't know the date, early January. So that is a factor in terms of some of the timing of what actually happened.
Sure. I think coming back to that, sorry, are you saying that the council completely closes for 2 weeks over Christmas? It's not open for the 3 days each week?
Yeah, there will be building standards, I believe, are always on call for emergency situations and probably other departments, but the planning service certainly closes down now completely for 2 weeks.
Right, so just to be clear, so everybody has to take leave for those 2 weeks. The whole department's closed down. Nobody can make a planning application, or at least it won't get validated. The whole service shuts down.
Yeah, and Shona Simpson, my colleague, did contact the owners of the property prior to the Christmas break to try to arrange a site visit, and that was not allowed to take place before the 18th of January due to their circumstances, holidays, etc.
Okay.
And we just would not, sorry to interrupt, we of course would not be issuing a BPN without a visit to the property. Not be appropriate.
Okay, so when did you visit the property?
We visited from the public realm prior to the 15th, and then we visited on the 18th with the owner.
Sorry, I'm just going to get this correct in my mind. So you served the BPN on the 15th of January, but you visited the site on the 18th.
Yes.
But you just, sorry to go around in circles here.
Oh, we visited from the public realm. We didn't visit internally until the 18th.
Okay, so you visited externally before that.
Yeah.
Okay, thank you. Yeah, sorry, it's just to be clear. And just going back to my question again about the Act itself, where it says, if it appears to the planning authority that a building in their district which is not a listed building is of special historic or architectural historic interest and is in danger of demolition. And I suppose that's just like how you considered that, because it wasn't in danger of demolition, it was actually in the process of being demolished. Is there a distinction there?
Yeah, I don't think so. I'm not a technical expert on this, unfortunately, Mr. Edwards. I'll leave it to my colleagues Alison and Shona, but I don't think there is a view on that.
So sorry, did you consider that in the sense that it was being demolished rather than it wasn't at risk of being demolished?
I think, as Alison said earlier, it added to the urgency of trying to protect what HES had stated was a building that merited listing.
Okay. Any further comments from the appellant?
Yes.
Not at this stage, so I think going to posting other issues. I should also say that Mr. Craig Donnelly's entered the room, another solicitor from Hunswick.
Right, what we're going to do, we're going to take a break just now and we'll come back at 12. Looking at the way this is going, I suspect we might need to take a lunch break and return. So we'll come back at 12 and we'll pick up, and I'll review it around 1. And if we feel like we need a lunch break for half an hour, we can take it then. Is that acceptable to everyone? Thank you. Okay, so I'll see you back here at 12. Thank you.
Thank you. Thank you.
Right. Ms. McDowell, could you just talk us through HES's process in terms of the second listing request? So the building preservation notice has been served, and HES now have a duty to review the designation.
Yep, thank you.
Sorry, just one second. Mr. Burnett, you wanted to say something.
Yes, just briefly, I understand we've just been through on the agenda 2F, G and H. And I just want to make one very brief comment on 2E that I don't think was addressed in great detail. The question there is confirmation that the initial decision did not limit the issue of a building preservation notice or a second listing review. There's kind of two questions there. And my observation would be merely, of course, there's no prohibition coming from the initial decision to stop the issuing of a BPN because they're a completely different system. So that's clearly there's no legal prohibition there. But the second part, whether there's a limit on a second listing review, again, there's no statutory prohibition on a second listing review. But I had already drawn your attention to HES's own policy in relation to whether it's appropriate to review a very recent decision or not. And that was in, albeit in the context of a decision to list. But in my submission, the same overall sort of advice and guidance is relevant that in normal circumstances, it not be appropriate to review or carry out a second listing decision immediately after a first one, unless there's some major change in circumstances. And that's no doubt what we're coming on to discuss, but it's just to point out the two different questions and the word of limit as opposed to prohibition here. I say that there may be in circumstances a limit or not a limit on reviewing it.
Mr. Gregg, do you have any observations in terms of the application of the policy, HES's policy, in terms of to list in this instance?
My only comment would be that there is no statutory impediment, as I think Mr. Burnett accepts, to the to HES undertaking that second assessment. And Mr. Parsons, I don't know if you've got anything to add.
Yeah, I think this was in relation to some published information on our website, which I think gives two examples. It referred, in our view, to when we have listed, whether we would review it in short order after that. I think that's the intention, is to refer to what we have listed. I think clearly in cases like this, where there is first a development proposal and second not a development proposal, for example, we would certainly review a decision. So I think the intention is to refer to whether we would go back on a decision to list.
Okay, thank you. Ms. McDowell, if you could take us through the second process, the second decision from HES's point of view. Thank you.
Okay, so we processed and assessed the site in the similar process as I explained earlier. On the 15th of the 1st, 2024, Glasgow City Council submitted a listing application for 124 Balmore Road and let us know that they intended to serve a BPN on the same date. We opened a new listing case and we published that on our portal. We looked at our previous assessment and considered and wanted to consider further to that what new information had become available about the building and its significance to ensure that our review and so we were going to move forward with an assessment to so that our understanding was up to date. We referred to the information gathered at our site visit on the 4th of January 2024, and we carried out a further site visit on the 18th of January 2024. At this site visit, we saw parts of the interior, and our Heritage Research Service team was with us and undertook a photographic survey of the building. We saw that parts of the roof had been removed. We visited the building again from the public realm on 24th of the 2nd of February, 2nd of February, 2024. We also had the opportunity to view architects' drawings, plans dating to 1932 that are held in the Dean of Guild Court at the Glasgow City Archives. That's something we hadn't seen previously. With that information, well, we consulted on a proposal to list the entire building at Category C. We opened the consultation on the 7th of March, initially running that for 3 weeks. But we extended that until the 15th of May. We also put a consultation on our Citizen Space portal, on Citizen Space for public consultation as well. We extended the consultation, as I said. We were communicating with the appellant at that stage, and we thought that it would be useful if we extended the consultation to allow them time to give us a full response. Just to say, we received 26 responses to the consultation from members of the public and including the owner. All of the responses, apart from one, were in favor of listing. The consultation responses that we received, which were considered material to the decision making on special architectural historic interest, mostly were concerning the setting and the social historical interest of the building to the community, and for its interest as a surviving cinema. So those are the things that were put forward that we thought were relevant to our assessment of special architectural historic interest from consultation comments. The owner responded with concerns about economic impact the listing might have on them, and that the listing would prevent development. And no comments were made that referred specifically to architectural historic interest, but they did refer to structural integrity of the building, and they suggested that we consider listing the middle section only of the front facade of the building. So once the consultation closed, we reconsidered the merit of the building with all of the information we had available to us. So everything that was said to us in consultation, the archival information that we reviewed, the information we gathered through our site visits, and all the comments made in consultation. We balanced this against the listing criteria and the selection guidance. We decided, based on all of that information, that the front part of the building only met the criteria of special interest, and that we would specifically exclude the rear, the auditorium and part of the rear, and all of the interiors. On balance, we considered the parts that are excluded not to meet the criteria of special interest, primarily because of the level of loss to the fabric. The decision to list the front part of the building reflects our views that the loss of fabric has not adversely affected the front of the building, and that retained a significant level of architectural historic interest, and to represent its building type as a good surviving example of a cinema of that period. And we know, in terms of that type of building, that the front parts of the building are, effectively more decorated and of architectural interest. And in this case, the building, which sits on a corner site, is very prominent and represents still can represent its typology as a super cinema, as we've researched it to be. We understand that it represents that and contributes to its prominence in the local streetscape. So we wrote to the planning authority and the owner at the end of May to tell them about the change to our proposal on the extent of listing, and that a final decision would be made very soon. So that was towards the end of May, we did that, so that having received all that information. This is the view we had come to. And we took that final decision to designate the front section only. We then found also, because of the situation, there was a building preservation. The building is listed, but we confirmed that listing. So we authorized the listing on the 3rd of June 2024 and notified all the interested parties of the decision the next day. And in our report of handling, we summarized the consultation process and the consultation responses. So what we published online on our portal was our report of handling that reviewed all the consultation comments. We published all of the comments from the citizen space consultation as well. And we referred back to our policy within that summary. And when we referred also to our context of our decision within the context of the BPN.
Thank you. Just before I ask other parties, this is moving on to item J. From what you've said, my understanding is that the service of the BPN initiated the second review. But on the second review, there were new elements that you considered, that being the loss of the fabric of the building, which had occurred since demolition. And secondly, that you'd managed to look at photographic evidence of the original drawings of the building from the 1930s. Is that correct?
Yes.
So were those two material factors that you considered that weren't there in the first decision?
They hadn't changed our view on special interest in terms of we had come to the same conclusion, but I felt like the plans sort of reinforced our understanding of the architectural interest. We know the architect is a cinema architect. They were very competent drawings from that period and helped us understand the fabric and the detailing of the front elevation. And then we take a view based on all the information we have. I mean, there was a level of loss, but we that was our understanding. We reviewed our proposal that effectively the whole building met the criteria, and we reconsidered that. I mean, the owner had asked for us to consider the front part only, but we considered the special interest of that suggestion, and that we felt on balance that what if we were to consider the whole site, the front section, not just the front middle bit of the front elevation, was of special interest. So it prompted us, all of the information we reviewed, we received, prompted us to, just wait, do a final sort of assessment of all of that information.
Thank you. To the appellant, do you have any comments regarding the process for the second decision in terms of just the generality of it?
Not in relation to the generality, other than obviously the observation that it seems to have triggered a brand new process, even though they just issued their decision on the Friday and they start again on the Monday from scratch almost. And the observation at the end there that the only two elements that might have changed were the loss of the fabric of the building, which presumably would weigh against any listing, and then the photographic evidence, which I don't understand to have been crucial in the decision.
Yeah, just in terms of the archival information, it wasn't critical to the decision. It effectively confirmed our understanding of the special interest of those elements that we ended up deciding to list.
We just talked briefly then about the loss of the fabric of the building then. So you obviously had to consider that. Could you just talk me through how you considered that? Was it, obviously the roof is gone, so but there's still the external walls, but you've decided to list just the facade. Is that correct?
Yeah.
Yeah. So how did you come to that reasoning? Did you use the structural reports? Were you interested in the viability of the rest of the building, in the sense that, was it going to hold up? Did that come into the consideration at all?
As I referred to previously, the structural integrity isn't a consideration. It's not what we take into account. It's whether or not there's sufficient character in the remaining fabric. It was just over the course of assessing the building, in the second decision, in the second review, that we were able to take a measured view on what the extent of that alteration was, or loss of that fabric. So, and referring to the structural report, we hadn't been provided with that. We were told by email very briefly by the owners about the lack of integrity of this building now that the roof was off, and we were asking for full comments, and we acted on what we received at the end. That was just some brief summaries of their views on that. So we did understand that was an issue, but as I said, it's not a material factor in our decision making for assessing special interest for listing.
Okay, I just wondered whether or not, well, we have the two, I'm assuming, structural engineers here, so whether or not the facade is in its current state structurally safe, or is it the scaffold that's holding that up? Mr. Ward or Mr. Stevens?
No, it's not. It's not the scaffold that's holding up, but the original building was a mix of a steel frame and masonry to hold the thing up. The steel frame is at the rear of the facade, which is the masonry element. But what's happened as part of the demolition so far is the roof's been taken off, but some of the bracing, the steel bracing, it's been cut and removed as well. The roof cladding, which also extended over the external walls at the back down towards the ground level, that's been taken off too, which is exposing masonry brickwork that was to wind loadings, which it wasn't exposed to before. The roof cladding, the extended roof cladding, protected that. So the rear of it really is structurally much altered. Also, in some of the brickwork that's there, on the elevations, they're quite badly cracked. So basically, the steel frame and the bracing laterally supported the front facade, the masonry facade, and that's now, plus a lot of the balcony's been taken away, which again would have helped laterally support the masonry facade. So that's the situation now. There was obviously a significant storm recently that affected everyone really. Now, and it retained that, but that wind may well have weakened it further, the masonry, because obviously when the wind hits the facade, the masonry facade, it transfers into the steel frame, which is now gone or weakened. Would you agree with what I'm saying, Brian?
Yes, yeah. Essentially, as you say, the structure performed its life up to this point, being restrained laterally at the roof level, which was connected across the building, allowing the wind loadings to get back down to the ground. And there was internal ceilings, local floors and balcony levels that also restrain that, and that has all been removed. So it's currently functioning in a way that it wasn't in a new way for the first time in its design life, in a less favorable way. All while the loadings that will have been applied to it from the wind will have been changed, because the roof is removed, the rear is now open. So rather than the suction part of the wind loading applying to the rear of the building, it'll apply currently to both sides of that facade.
Yeah.
There is a large number of cracks and and movement in the internal walls as it was. So all of that's going to need to find a new load path through the building, which will result in areas where the minor defects had been acceptable as they'd been worked around, but they will be exacerbated going forward.
Okay, so we're going to work around the agenda slightly here, but in terms of all of those issues, one, I take it from what Historic Environment Scotland are saying that that wouldn't have been taken into account as part of the decision to list the building, being mindful of what we discussed at the beginning about what factors could be considered. But those would be matters that could be considered in a listed building consent application for say, demolition or redevelopment of the building.
Yes, that's correct, sir.
Okay, any comment from the appellant before we move on in the agenda?
Only so that I would say it's also a factor in the change context that's been brought about by the process, which has been, or processes that have been followed by the HES and the council. I mean, if things had been done differently, that new situation with the structural integrity would never have arisen. And I say that's a factor that can be taken into account in the overall decision.
Thank you. Now we're going to move on now to item 3, the designation policy and selection guidance. I hope we can get through these matters fairly quickly. So am I directing these to yourself, Mr. Parsons?
Yes.
So just confirmation that policy guidance it's non-statutory.
Yes, that's correct.
And if you could just outline the process for approving the policy guidance and any consultation that was had on it.
Okay, generally where this comes from, Section 2 of the 2014 Act, so that's the HES Act, gives has a general function of investigating, caring for and promoting Scotland's historic environment, and a specific function of protecting and managing the historic environment. Section 5 tells us to contribute as appropriate to the development and delivery of policies and strategies in relation to the historic environment. Designation policy and selection guidance was developed alongside HEPS, that's the Historic Environment Policy for Scotland, in 2018 to 19, following an extensive engagement campaign. So there was a kind of large-scale engagement campaign, which was referred to as What's Your Heritage, and that was the first kind of evidence gathering. Policy was drafted by HES and developed through a series of initial workshops and consultations with internal and external peer groups. External groups consisted of a variety of stakeholders, including heritage-led immunity and professional bodies, planning consultants, local authorities, Scottish government, and special interest groups. We published a draft policy on our website as part of a formal consultation period. The draft was also subject to impact assessments. Following consultation, we collated and analysed responses, and we published a consultation analysis and report that's available online still. I don't know if we supplied that to the reporter or we referred to it at the Craig Hall Road hearing. Final policy was agreed and approved by HES and published on the 5th of April 2019 and came into effect at the same time as the new Historic Environment Policy on the 1st of May 2019. We launched the policy through the Scottish Government Improvement Service in the form of a webinar at the time. I think it's worth just noting that during consultation, clarity around listing when there are development proposals was raised as an issue by consultees. Our response was to provide further information in our policy about the circumstances in which we may list in the case of advanced development proposals. And we've set that out in our consultation analysis publication.
Thank you. That's helpful just to set the context. So if we're all happy to move on, let's look at the policy guidance itself. And specifically, I think I'd like to look at page 7, where it says the code expects that the functions we fulfill are transparent, accountable, consistent, proportionate, and targeted when needed. What exactly does that mean in the context of this case?
Just very brief background. Since the policy was introduced, we've also set out our regulatory principles in a document called our regulatory framework. But both the designation policy and selection guidance and the regulatory framework refer to the Scottish Regulatory Strategic Code of Practice published in 2015. Code of Practice outlines how Scottish regulators should apply regulatory principles and build good practice when setting regulations. As you've said, the code expects that our regulations should be transparent, accountable, consistent, proportionate, and targeted only where needed. Our view is that our policy and practice is consistent with the principles of the code, and that the 2 decisions we made on this site are also consistent. I'll go through the points individually, but transparent. We publish designation proposals, we notify interested parties, we seek and publish views on our proposals, and we provide detailed reports of handling, including in this case, a report of consultation. Are we accountable? Well, when we decide to make statutory changes to the list, these decisions are subject to appeal, both through the appeal process and ultimately through the courts. Our policies are subject to public consultation. We're subject to FOI and EIR and have a complaints procedure responsible ultimately to the Public Services Ombudsman. HES governance is established to maintain accountability in all the work we do, and that's set out in our regulatory framework, which is published online. Consistent, our policy and selection guidance and our internal desk instructions ensure a consistent approach to all cases and provide for robust, consistent decision-making. Moving on to proportionate. Our selection guidance ensures that we're selective in our approach to deciding which buildings to add to the list. We apply exclusions when appropriate to ensure that regulatory processes are only applied where necessary. Our proportionate approach also recognises the role of the planning authority and the planning process, as we do as when we introduce that policy around development proposals. And finally, sorry, I should also say that our proportionate approach is also what dictated our final decision on which elements of this building to include in the listing. And finally, targeted, our approach to responding to external requests that ensures that our resources are targeted to external needs. I'd like to take any questions on those.
Thank you. That makes sense. Just in terms of regulatory principles, is Historic Environment Scotland also guided by having to make decisions in the balance in terms of those for social, economic, and environmental considerations, or is it solely on the special architectural and historic interest of a building?
Set out, I suppose, in HEPS is that the overall framework sets out, I suppose, that overall balancing. The designation policy and selection guidance is within that framework, and the designation policy and selection guidance guides the individual decisions and sets out, in that case, the specific issues we take into account in those individual decisions. So there is a distinction, I think, between the overall framework and the specific decisions governed by the selection guidance and policy.
Okay, any comment from the appellant or anyone else before I move on in the agenda?
Just a comment. So you asked for a question whether the solely took into account the architectural interest. I took from, and whether there was any discretion or decisions in the balance, I took from the HES's answer that it's not solely on architectural interest given the matters he mentioned and the policy. But he didn't give you a yes or no answer to that. But that's what I took from it.
Okay, would you like to confirm, Mr. Parsons?
The decision on the listing takes into account those factors that are set out in the designation policy and selection guidance. Obviously, there's discretion within that in applying that selection guidance.
I mean, what I heard you say, apologies if I got this wrong, but you said there was a distinguishment between the HEPS policy and decision making, in a sense that you're saying that the balancing of economic, social, and environmental factors is fed into your policy making approach, but in your decision making, just to be clear, you're only looking at the special architectural and historic interest of the building. You're not looking at social, environmental. Obviously looking at social in terms of a historical context, but you're not looking at the benefits or disbenefits of those three functions.
That's how we have described it, yeah.
Okay, if we can move down to, I think it's on page 7 again, of the policy and guidance, you're right. We normally avoid interfering unnecessarily in the planning process or other regulatory processes where there are development proposals by adding a new designation. What does that mean by we normally avoid intervening, Mr. Parsons?
Yeah, this part of the policy explains our approach to designations when there are development proposals for a site. It explains, as you set out, how we will normally act based on the information we have on development. This part and the subsequent detailed points are subject to the application of judgment in the individual circumstances of the case. So in the 3 bullet points you'll probably get onto. In most cases that we deal with, there are no unusual or exceptional circumstances, and we do not designate where development proposals are clear. However, in this case, the service of the building preservation notice was exceptional, it was not normal, and it led us to the application of a separate part of our policy.
So I realize that this might be covering old ground because you're in the last hearing, but for this, it's fresh. I just want to understand. So first and foremost, the service of a building warrant, was that another regulatory process that you considered was at an advanced stage?
In this case, yes, we took a view that the application for, and more importantly, the granting of a building warrant for demolition amounted to what we considered to be advanced development proposals.
Okay, we're going to come on to what the BPN, what the policy says about the BPN after. So in this case, with the initial decision, you wouldn't intervene because there was a building warrant granted. Is that correct?
That's correct. And that was the advanced development proposal that we identified. And by stating the obvious, I suppose, is that there was, in effect, permission for demolition, and that was, I suppose, would have a fundamental impact on the special interest of the building.
Now, what I'm trying to understand as well is that the reason I asked you would it apply to a building warrant is that I can see when there's a planning proposal, so there's something granted on the site, there's something that you can see after going to occur on the site. But in this case, my understanding is that there were no further proposals. It was just demolition of the building, and then I guess proposals would come down the line. Is that correct?
I don't think we have a view on whether proposals would come down the line or not. Our understanding certainly is that permission was given for demolition to take place, that the demolition didn't otherwise need any other permission. For example, it wasn't in a conservation area, and I won't, others can talk about the kind of planning situation, but that no other consent in the planning process would be required for the demolition. Therefore, demolition was permitted and could begin on the site. So yes, certainly in our view, we consider that to be an advanced demolition proposal.
Yeah, I suppose what I'm trying to understand is that I'm trying to make this distinction. You wouldn't normally intervene in a planning process where you can see what the end game will be. You can see that there might be a proposal on the site, but in this case, it was going to be a vacant space of land. So I'm just wondering if that played into your consideration at all, or if not, you just thought there's a building warrant for demolition, we won't intervene.
The latter, I think we wouldn't and didn't consider the merits of any future use of the site.
Okay, but I suppose that's what I'm trying to understand. Would you normally consider the merits? Is that why there's we won't intervene because we can see that there's going to be something down the line?
No.
Okay.
What we're recognizing is that the planning process is separate, and that's, I suppose, our decision about how our policy sets out what we consider to be proportionate.
Okay. Before we move on, Mr. Burnett, do you have any comments?
Not at the moment, so I think it's probably easiest to address everything in the round at the end of this section.
Okay. Yep, no problem. Okay, so on page 7, again, you've alluded to these, Mr. Parsons. There's 3 bullet points. Could you just talk me through the consideration of those in this case?
Yes. The policy doesn't set out specific criteria or measures, and provides for the application of judgment in individual cases. In cases where this part of the policy applies, we set out why we consider the proposals to be particularly advanced. Definition can vary according to circumstances and allows discretion based on, as I said, circumstances. Generally, for example, we consider that if there's clearly a live planning application, that would be advanced development proposals, or a consented development or a refused development within the appeal period. For example, depending on circumstances, in many cases, that definition of advanced development will extend beyond the live planning situation in the formal sense. We might consider, for example, a large-scale strategic infrastructure proposal where there's been a clear council intention, public consultation. And yes, as I say, it's not necessarily a planning application. The first and the second bullet points also provide some scope for discretion and judgment. For example, where there is a live and non-contentious development proposal which affects a small part of the site, we may still proceed with the designation. Or where a designation proposal wouldn't have a meaningful impact on the planning process or the development process, we may progress. We often make our final decision after we have carried out a consultation so that our decision is subject to clarification and opinion of stakeholders. So both information on development proposals from the local authority, but also from the owners. But also we would seek to have some, where possible, opinion from the local authority and others on the status of the development proposals and whether we should consider them to be advanced. Obviously, the decision is ours, but we take use on that into account.
So we're going to move to perhaps what's a distinction. So in the first case, you're saying we normally avoid interfering unnecessarily. Now, when we look at a building preservation notice, when that's been served on page 8 of the policy and selection guidance, In urgent cases, planning authorities may consider serving a building preservation notice if it appears to them that a building is of special architectural historic interest and is in danger of demolition or alteration which could affect its character. This is a form of temporary listing. Once a BPN has been served, we have 6 months to assess the building for listing. We may list a building in these circumstances, even if there are development proposals at an advanced stage. So how did that apply to this particular case? And what I'm really interested in is the word may. So we may, so there's a level of discretion, judgment there. But that was the same in the initial statement. We normally avoid. So there's a discretion and judgment again. So maybe you could just talk to me about the distinction between the two.
I suppose the policy describes a specific, or this part of the policy describes a specific approach in the circumstances of the building preservation notice. In our view, I suppose the policy recognises that a planning authority has made a decision to serve a building preservation notice, and that changes the circumstances in which we consider the development proposal. I think the distinction is between what is normal and what is exceptional. I think in the first decision here, we considered this to be normal. This is not unusual for us to see a case where there are development proposals. Local authorities are aware of our policy. We make them aware that we're considering the listing. We make them aware of our policy. And in the normal situation, there is no further intervention. In very many cases, we proceed to issue a report and to not list a building. Those are the normal circumstances. We considered the service of a building preservation notice to not be normal, to be exceptional, and so we applied the specific part of the policy that relates to that, which of course allows discretion. But we had to consider. We considered whether there was. We considered the situation afresh. It was a new decision. We implemented, or we took into account this part of our policy, which we think permitted us to list the building.
Thank you. No, I understand that. What I suppose what I'm trying to understand is what is the difference? So you're saying the first decision, that was normal. That was normal circumstances. There was an advanced development proposal. In the second situation, the second decision, the council had served a building preservation notice which was abnormal, and that changed the outcome to being, we'll list it now. Is that correct?
That's correct, yes. I mean, it wasn't a kind of automatic, but yes, it introduced for us a policy provision to list the building. Given our general functions as set out in the HES Act to manage and protect the historic environment, given our duties set out in the 1997 Act, to make a list of buildings, I suppose there is a reasonable public expectation and reasonable public expectation that unless there was a specific prohibition against listing a building, that we would list it. In this case, it appeared to us that there's no reason why we should not list the building. I think it might be useful, I suppose. I don't know to go into ancient history, but we think we probably will get into this later. But we think that the intent of this policy provision is quite clear. It is intended to introduce an exception. That's what we took from, I suppose, our consultation on this, and that's why we amended the wording. It dates back to really the 1980s and the 1990s. If you go back to the 1990s, it is set out very clearly in policy at that stage. as a specific exception. We can provide the reporter with any of this information, but the memorandum of guidance, the old memorandum of guidance, had this specific, had set this out as a specific exception and said, generally we won't list. There is an exception, which is when a building preservation notice is served. We think that policy intent is clear, that we should treat these kind of cases differently when a building preservation notice is served.
Yes, I mean we could probably talk in circles about this, but I'm just trying to understand that they're both not black and white, so they both require a degree of discretion and judgment, and they're both within a non-statutory policy/guidance document. Is that correct?
That's correct.
Yes. So it's what changed between the first decision and the second decision. So you've got a site where you know it's being demolished. So since the first decision, it's being demolished. You're losing the fabric. It's being degraded. And there's no future proposal for that site. So what was it that changed other than is it just the fact that the council said, I think you need to rethink this?
Those are your words, not mine, if you don't mind.
Well, you know what I mean, though. Is it because you've been asked to make a second review within a very short period of time? What is it that changed? Bearing in mind that both of these policy tests required judgment and discretion, what changed?
Our view is that the council made an active decision to serve a building preservation notice, that the council has decided that the building is of special interest. The policy intent is to provide for a different decision when the building preservation notice is served. That to us is the material change in the circumstances, is the service of a building preservation notice.
Okay, now let's look at and I'll come to yourself, Mr. Burnett, in a minute, but let's look at the two decisions, specifically the second report of handling. Can you point to which sections there describe this change in circumstances and why the building will now be listed as a consequence of the building preservation notice being served?
I'll need a couple of minutes to get the report of handling, if that's okay. I think I just hit the first one here. Let me find it. Right. Yeah. Three 3.3, and I'll accept that there isn't a great deal of detail here, and we have set out in our submissions a little more detail at that. But in our policy considerations at 3.3, we've set out the policy, and we've set out the specific policy around building preservation notices. And we have simply said in this case, we decided to proceed with the assessment and a proposal to designate while there are designation proposals affecting the site. So yeah, that's where it's set out. We have described the policy, and we have set out the decision that we made to list the building in the context of that policy.
So, I mean, it's factual. You're just restating what your policy is. And if I'm correct from what you've said, the only area of what I would call reasoning is that last sentence at the end of 3.3. In this case, we decided to proceed with an assessment of the site and a proposal to designate while there are designation proposals affecting the site.
Yes, that's correct.
Okay, so you're in agreement there. There's no other area where you've come to a reason. You set out your reasoning and judgment about why there's been a change in circumstances, why you've agreed to now list the building.
That's correct. In the report of handling, we've set out in our appeal submission a little bit more detail.
I know I'm crossing over certain elements here, but from the appellant's point of view, you look at the first decision. Now, in the first report of handling, you're aware that the council may serve a building preservation notice. It's stated within the report of handling. But you don't consider that the policy for BPN applies yet because the BPN hasn't been served. Is that correct?
Yes, that's correct.
Okay. And then where in this decision, the report of handling, do you come to your reasoned judgment? Is it again at the end of 3.3? In this case, we've decided that the extant building warrant for demolition means that we should not list the building at this time.
Yes. We have a little bit in 3.1 where there's a little bit of factual background, and the application of that is set out at 3.3.
Okay. So from the appellant's perspective, this is what I'm trying to understand here. They get the first decision of yourselves, and it has this sentence that says, you've got an extant building warrant. We're aware there might be a building preservation notice coming, but we're not going to list the building. And then in the second report of handling, the decision is we're going to list it, but there's no explanation other than what the explanation there is that we've decided to proceed, and while there's a designation affecting it, well, in other words, while there's still advanced proposals, we're going to list this time round. So from the appellant's perspective, what do you think they could take from that?
I don't think I can answer that. Well, I think we have sought to make clear in our first report of handling that we were aware of the discussion around the building preservation notice or potential building preservation notice. We certainly sought to make that clear to the appellant and any other interested parties that this discussion was in the background and that we're aware of it. We also sought to make clear that, in our view, our policy would introduce a new provision if such a notice was served. Sought to make that clear. How the appellant or others read that, I can't comment on. Certainly that was our intention, to make that clear.
So from the appellant's perspective, Mr. Burnett, just in terms of those two report of handling, we'll come to the whole section in a second, but in terms of those two decisions, what did the appellant take from those two?
Well, from the first decision, take that HES has considered the situation on the ground, has considered its policies, and although recognising that the building has historic interests, has applied its policy in relation to the advanced proposals for development, and has decided on balance that they do not regard the building as worthy of listing in the particular circumstances of this case. And the appellant is at a complete loss to understand why that has changed purely because of the service of a BPN, which is a purely procedural matter. And I think it's just been confirmed by HES that the first decision was how they would normally process a matter, and the BPN one was the abnormal situation. But in my submission, the BPN is normally, and although it's not an often used facility, it's envisaged that will happen before HES take a decision in order to give HES purely more time to take a decision. And it's a purely procedural matter that brings the matter before HES. It should have no effect on HES's weighing of the decision. Otherwise, as they say, I think they put it themselves, Glasgow City Council have decided that it's of interest, but HES are the people who should be making the decision, and they've already had Glasgow's view in relation to the first decision. So it makes no sense to add into any weighing exercise merely the fact that building preservation notice has been served. That's a purely procedural matter. It's nothing to do with the actual merits of the decision. And it is incomprehensible to the appellant, given that by the time of the second decision, they literally just had the first decision. And since then, matters, if anything, have moved on in relation to the advancement of the proposal. So to say it's anyway fulfilling what they claim in the first part of their policy in relation to the code, that it's consistent and transparent, just makes no sense whatsoever, because there's completely inconsistent decisions about exactly the same matter on essentially the same facts.
Apologies all, I just lost internet connection. The risk of doing a hearing from a rural area, apologies. So Mr. Burnett, you were at the point of saying it makes no sense to take account of a BPN as it's purely procedural, and that's where it got to. Sorry, I can't hear you, Mr. Burnett.
Sorry, sir. Yes, from the appellant's point of view, if anything, matters have moved on in terms of the advancement of the proposal since that time, and it makes no sense to change the merits of the decision on the basis of a procedural matter. And in my submission, it goes against what the code expects in terms of consistency and being proportionate and targeted. It appeared they'd taken the decision on the basis of the policy in the normal way. And there's no reason, and it seems incomprehensible why that would change just because they consider it again at a later stage.
Historic Environment Scotland, would you like to come back with anything?
Just to say, sir, that from the perspective of Historic Environment Scotland, the second decision was made in a different policy context, different policy provision applied, in particular the policy relating to building preservation notices, which provides that HES may list a building in circumstances, to paraphrase, when a building preservation notice is served, even if there are development proposals at an advanced stage. And as we've heard, that's a policy statement which was deliberately included in response to consultation feedback and recognising the long history of that particular policy exception, to provide clarity on when HES would set aside their usual approach and on when they would intervene and designate buildings despite the existence of advanced development proposals. So that's the intention behind the policy. And I would submit that that's also the effect of the policy. And the second decision that was made by Historic Environment Scotland in this case was made in accordance with that policy. different policy contexts.
I suppose, well, you've had an agreement. Both of the policy approaches are both discretionary and a matter of judgment. I do wonder why is the wording it says we may list a building? Why did it not say we will normally list a building? It seems very obtuse. It doesn't sound quite right. Both of them have a decision to make, but it's not, in my mind, I'd like you to explain to me further why there is this strong distinction between what the two parts of this policy say.
So I can pass over to Mr. Parsons for more in-depth explanation, but in terms of why I think with the benefit of hindsight, you can always rewrite policies to make them more explicit. But to my mind anyway, the intent behind the policy here of having this exception is to balance the role of Historic Environment Scotland in managing the historic environment and cultural heritage with the role of planning authorities in managing development in their area. Mr. Parsons, do you have anything to add?
No, and also with the benefit of hindsight, we would set out and explain the reasoning behind that decision in more detail. That's accepted. I think what I referred to earlier, I suppose, is that we have a general duty to manage and protect heritage, a specific duty to make a list, and to us, an understanding of a reasonable expectation that we would list a building, we would add it to those lists, we would provide that protection unless there's a specific policy provision against it. I think our view clearly is that we made two separate decisions, both align with our policy, both comply with our policy. But as I say, I think it was it is reasonable, it was reasonable to list the building in this case. There's no specific reason against it, and as I say, our general role is to add buildings to lists and provide that level of protection.
Just to add to that, sir, you asked about the use of the term may. Why does it say may instead of shall normally or something like this? And may is a permissive term, so it entitles that decision to be reached, but it does, as you acknowledge, retain that element of discretion as well, which is appropriate in policy and guidance.
Mr. Burnett, any further observations?
Not really, sir. I think there's no real difference between may and normally. In both instances, HES are entitled to list the building having regard to the full remit of their policy. And it shouldn't depend on a procedural aspect, which is all the BPN is. You've asked to explain the reasoning, and the only thing they point to is the service of the BPN, which is not relevant change in circumstance in relation to the decision that has to be taken, balancing the proportionality of the listing with the advanced stage at which the proposal has reached. It has no effect on that. It's not a relevant change in circumstances for that decision.
Okay, so now I'm going to come to the well, not so hypothetical, because this is what I will be doing, but I obviously have to make a decision on this appeal. Where does it sit with myself in making a decision afresh? It doesn't seem to be between parties. You seem to agree that it's not a review in this case, it's making de novo decision. So where does this sit with myself in terms of, I know there's a building preservation's been served. You've explained to me the reasons why or why not the decision has changed. So where does this sit with myself in terms of making a decision? Am I just to look at the procedural fairness that's been raised? Do I take into account, and I suppose this is summarising in a sense what we've discussed, but do I take into account any socioeconomic or structural integrity issues? And ultimately, even if I find that there are issues there, am I only to look at the special architectural and historic interest of the building and say, well, let's say hypothetically this has been an unfair process, however, the building facade still retains special architectural and historic interest, and so the listing should remain. Any thoughts? Mr. Gregg?
Yes, thank you, sir. I would agree that your role here is to reach a fresh decision on the merits of whether or not the building should be designated. And in my submission, in order to do that, you should consider whether the building's of special architectural or historic interest, as that phrase is used and explained in Section 1 of the 1997 Act. And you should also base your decision on whether or not the designation would be in accordance with the designation policy, which has put in place. In terms of any comments on the procedural fairness of the process that's been followed to date, I think you do need to understand where the decision making that HES have employed and the rationale behind that. You may wish to comment on that in your report as a central issue, but in my view, I don't think that those conclusions should be determinative of the appeal itself. I say that because I don't see anything in the legislative framework or in policy that would indicate that that was the case. I don't see anything in previous decisions or in analogous decisions that would, in the planning context, that would enable the reporter to reach conclusions on those grounds that are determinative of the issues before us. But I certainly think they need to be addressed. So that would be my view on how you should approach your decision making here.
Mr. Burnett, any thoughts?
Yes, sir. Obviously, you will need to consider the architectural merits of the building, but you do need, in my submission, to look at the whole context of the decision, and in particular, look at the first decision made by HES as they were then minded to weigh the matters, including all the factors that are before you, and came to a decision that the building did not merit being listed because of the advanced stage of development. And that should be the starting point, because no proper explanation has been given as to why that has changed. So applying their policy in its normal way, and you should have regard to their policy in the same way, and take cognizance of the first part of the policy on page 7, both with reference to the transparency and the consistency and the proportionality of the decision and the advanced stage of the proposal. Those are all matters that you have to take into account, but you also have to take into account what has gone before in this circumstance, including the first decision, and also that matters have moved on since then. So what, in my submission, HES has not done in the second decision, they seem to have ignored the first part of their policy and think they have a separate policy in relation to applications that come before you on the basis of a BPN. But that makes no sense. They should have a policy that seeks to discover whether or not a building is worthy of listing. And when they took that decision the first time, they came to a view, having looked at all those circumstances. And if anything, the circumstances have changed considerably in favour of the applicant or appellant here. And it is quite unlike the Vice case that you're having to consider, I understand, at the same time, where my understanding is Mr. Vice's planning proposals had perhaps lapsed or were not any further forward. Here, the appellant's proposals for the building have moved on considerably, and that is a material consideration in your decision, and that moves it even further, the weighing of the various factors in favour of the appellant. So, and obviously, the consistency of decision making in itself is a matter that you can take into account. It would be very unfortunate if there was an indication that HES is entitled just to take different decisions purely on the basis of the procedural route that it comes before you on, and to change its mind when an applicant has relied on the first decision in the first place. And that is a factor you can take into account as well, sir.
Thank you. Just on that point you made, you referred to the Weiss case, and then you said here the appellant's proposals have moved on considerably. In what way do you mean? So the building, the second decision, the building had already been demolished to a certain extent. Has something happened in the recent past that I should be aware of?
Well, not. I mean, so that there are obviously economic consequences for the appellant in terms of their proposal being stopped mid-development. But the point is, in Vice, the developer had not started on their development. But here, when HES took its first decision, it already knew what the situation was. And there's no change here in that regard.
Sorry, Glasgow City Council, you have a point. Sorry, I can't hear you.
Sorry, Mr. Edwards. Can you hear me now?
Yes, thank you.
Just to confirm from my planning colleagues, there's still no planning application in place for this site.
Okay, thank you. I think we've extinguished everything within this particular item, unless anybody would like to say anything else. No. I'm looking at the time, and there are only a few more items left, so I think we could press on if that's okay with everyone. Yep, okay. So the appeal building and its setting. Now, from reading everything, it appears to me that there's no dispute between parties on the special interest of the building that remains. Is that correct?
Well, sir, it's a matter of view of HES about the merits of it. Obviously, the building that is there is different from the one that they first assessed and is a lesser building, but we've already discussed that issue.
We can stand by the comments we made about special interest already.
Okay, thank you. Now, in its, I think we've discussed this as well in terms of loss of fabric, but just to confirm, in its current structural state, the building is still worthy of designation in terms of just the front facade?
Yes, sir.
Okay. Now, just when I was there on my site inspection, I noticed there's been some alteration since the building has been first built. Including, it looked to me, rooftop apparatus and plant, shutters, rendering, painting, advertisements and graffiti. Do any of those changes alter its special interest?
No. Am I going to answer first? No,
Yes,
I don't think. Yeah, we don't think that this has substantially altered the character, and the character has been retained. Our assessment has taken into account later changes to the building with regard to what you've noted. And on balance, we find that what remains is, and what is legally included in the listing of this, is a special interest. We made a decision based on what we know of the building at the time the decision was made.
Okay, any comment from the appellant?
No, so obviously this is a matter of discretion and subjective view for you to decide now, but we do note that it's only the facade that we're talking about now. There's no proposal by HES to re-extend the designation. It's purely the facade that we're talking about. So it's a matter for you to look at the changes in relation to that element of the building only.
Okay. And then finally, I've got an additional point here before we come on to the last item. I'm just wondering what the current status is of the building warrant.
Sorry to interrupt, sir. I think I had something to add on that.
I just wanted to make clear it's not just the facade, it's the front section of the building that has a stepped elevation, and the way that it comes around in terms of the corner and setting, and there's some mass in that front part of the building that basically is the character of an Art Deco building to its front section.
Yes, I see that. Sorry, I'm reviewing my photos from the site inspection. Yeah. In terms of the current building warrant, I take it now that's been somewhat enacted upon. Does that now, you won't have to reapply for the building warrant, but I presume if any further demolition or works would require listed building consent. Is that correct?
Yeah, we've had communication with the owners of the property about any further works. They would need listed building consent for any further works to enact that demolition warrant.
Okay. Thank you. Anything else in terms of the appeal building and its setting? No, in that case, moving on to any other matters. Now, these have all been published. Since the appeal has come in, we have had correspondence to DPA from interested parties, those both for the listing of the building and those against the listing of the building, citing the impacts that might have and the benefits of the building being listed. Furthermore, this morning, and this is just a further iteration of several emails from this party, but I'm aware that there is a petition which is now up to 3,000 signatures to have the building listed. I just wanted to give parties the opportunity to comment on both the support and for listing and for not listing the building, and if they had any particular observations in terms of the petition. Mr. Burnett first.
So I don't think that you really add anything to matters that have already been raised and responded to by the appellant. This is not just it's not a numbers game on sort of a voting basis, and the petition is what it is, but one cannot really interrogate the numbers or who is actually contributing to the numbers on the petition. I had a look at it last night, and the various comments that didn't necessarily indicate that it should gain much weight purely by the numbers, but I accept that is there, but it's only a minor consideration for you, sir. You already have submissions in relation to the views of the public, and it's more important your view now.
Okay, anything from Historic Environment Scotland?
I don't think we have anything to add subject to Mr. Parsons. Do you have any comments?
I think there is some evidence. I suppose your view on what weight to give that, but there is some evidence which adds to the understanding of social historical value in the comments. Not so much as Mr. Burnett says, just in terms of numbers, but there is some evidence of social historical value, which is we think is probably worth you considering. I've just noted that something that's happened with the petitions website. I think the comments are not right. So there's a set of comments which aren't now appearing, and that I'm sure will be resolved.
Okay, so when you're referring to social historic value, do you mean from people saying, I used to go to this when it was a cinema in the past?
A bit more than that. I think there's some commentary on what the cinema adds to the area and adds to the understanding of the development of the area. But like I said, I did try and check these comments yesterday, and there's something that's not quite right on the website, so I'm not going to point anything.
But those points are captured within your report of handling.
We've described the evidence we had when we made our decision. I'm suggesting is that there is some further evidence in here which I don't think would change the overall view, but is worth taking into account.
Okay. Glasgow City Council, any comment on that particular point?
I don't think it would be particularly appropriate to comment on a petition that would be a different circumstance if it was associated with a live planning application for the redevelopment of the site that may or may not incorporate the now listed facade. Then that would be a material consideration for us to take into account in our deliberation of that. But it perhaps reinforces the validity of the listing assessment in terms of the perception of the historic structure.
Does anybody have any other matters that they would like to raise? Mr. Burnett?
No, sir. Obviously, just refer to our submissions that's already been made, and in particular the response to the HES submission. I think was our submissions dated the 4th of October, and draw your attention again to that.
Okay, and from yourself, Mr. Gregg?
No further matters to raise, sir.
Okay, Glasgow City Council?
No further comments, Mr. Edwards.
Okay. Now, I did offer at the beginning for any party to summarise their case orally at the end. I do, however, feel that I understand all of your positions. I've taken a comprehensive note, and obviously the proceedings have been filmed, which can be reviewed again after. So on that basis, does anybody would anybody wish to give a summary of their case? Mr. Burnett?
So I think you have all the points, including the unfairness of the procedure and the inconsistency. I think you have all the points for the appellant, and as I say, I'd refer you to the submissions.
Thank you. Mr. Gregg?
Likewise, sir, I think you have Historic Environment Scotland's position on all the matters that we've raised and discussed. Obviously happy to address any further issues that might occur to you at this stage, but I think you have our evidence on matters.
Okay, Glasgow City Council?
No further comments, Mr. Edwards.
Thank you. Well, all that remains is for me to thank you for your participation and helpful discussion today. Following this hearing, I will write up the decision, which will be issued ahead of its target date, which is the 6th of June 2025. Are there any final questions about the procedure? No. In that case, thank you again, and have a good afternoon.
Thank you.
Thank you, sir. Good afternoon.
Thank you.
Thank you.